Hey everybody, Robert Chesson here, Landlord Law Firm, coming at you with our June installment of the video portion of the Landlord Advocate. Now, this month we're going to tackle the topic of quiet enjoyment. I've recently had clients who have asked for some lease review work and I've stumbled across this phrase and the concept of quiet enjoyment numerous times, and so I figured I would share it with everyone to help educate everybody on what quiet enjoyment really is. As you can tell from the title of this video, it is often brought to a landlord's attention by a tenant who is claiming they have a right to quiet enjoyment, that their neighbors are disturbing them, and that you, the landlord, have an obligation to solve that problem. Well, unfortunately, or fortunately for you, I guess, that is not the case. It is not a concept that deals with the neighbors, and I will clarify that as well as we go through our little video. First thing I want to do is start out with a little definition that I found that I think gives a pretty good insight on what quiet enjoyment really is. The covenant or promise of quiet enjoyment means that you, the landlord, will not do anything to disturb your tenant's rights to peacefully and reasonably use their rented space. It's also expanded a little bit to mean that you will not act in a way that prevents their peaceful use. And some examples of that include if you ignored a major rodent infestation or failed to fix a leaky roof that otherwise deprived them of their ability to use their apartment. Quiet enjoyment is specifically between the landlord and the tenant. It is either written directly into a lease, or in many instances it's implied. Even though it doesn't necessarily exist in the lease, it'll be implied by the courts, and it's implied in the law, and it is used to enforce sometimes your obligations to manage the property effectively, because your failure to do so has impacted a person's ability to use their apartment. It does not mean, unlike what your tenants might suggest, that it guarantees a noise-free premise. Found another interesting quote from a court that says, "It does not mean undisturbed by noise. Though the word quiet is frequently used with reference to noise, quiet enjoyment means without interference, without interruption of possession." So that's the legal jargon. What does that really mean? Well, that means although your tenants have a right to quiet enjoyment, that impacts you or implicates you, because if you are banging on their doors at 2 o'clock in the morning trying to collect rent, if you are ignoring a smoke alarm malfunction that is otherwise blaring throughout the night, those are things that you're responsible for, and your failure to address those may in fact disturb a tenant's quiet enjoyment, and is something that they might have you might have liability for. It has nothing to do with the neighbors, the vacuums, the babies, the people running up and down the hallways, or the street noise outside for that matter. Those are what we call a nuisance in the law. And a tenant who is creating a nuisance is a problem, obviously, but not necessarily one that you have to solve. One of the things we often tell clients is, obviously, if somebody's reporting a problem, as a customer service component of your business, you may want to address it if you can. You may want to reach out to the source of the noise and ask them to be more polite, be more considerate of their neighbors, and recognize they live in a multi-family community. If that doesn't solve the problem, you may have a right under the lease to address that person's conduct because they're creating a nuisance. You do not, however, have an obligation to do so just because the tenant downstairs brought that to your attention. So, with that said, if it's written specifically in your lease, one of the recommendations we suggest is adjusting the lease language. If you specifically contract to take on that obligation, you're potentially impacting your liabilities in a negative way, and it may be worth taking a look at. Alternatively, since it's usually implied in all lease contracts, you may still have some sort of obligation to deal with a situation, but it is a situation that you created, not one that was created by a neighbor. I hope that helps. If you've got any questions about quiet enjoyment and what that means, or how your lease reads and whether or not it imposes additional liabilities on you, feel free to reach out to your landlord attorney and have them take a look at that and make sure that your lease language regarding quiet enjoyment reflects exactly what you're trying to do operationally in your management of the property. I hope this was helpful. I look forward to seeing you guys again next month here on LLF TV in our Landlord Advocate. And as always, it's a pleasure.